Prashant, Anand Kumar, and members of the organizing committee, Dilip Kumar Singh, Akanksha Tiwari, technical committee, RKM Tripathi ji, Sumit Kumar Singh, for requesting me to come and share some of my thoughts. So when I got a call from the Narendra Singh, so I thought just maybe for 5 minutes or 6 minutes I have to speak or I go. But when I studied, I saw the program. So great responsibility has been given to me, and on a topic, uh, I'm just learning on that topic. But what is important for a law student, law teachers, and all academicians to examine, assess, evaluate, and think about how the new development is affecting or benefiting both. It impacts positively and negatively uh, existing education system. So the broad theme of the conference, which is very important, and that is the algorithmic justice, reimagining due process in artificial intelligence. Before I start talking about the artificial intelligence, I have for last couple of months, beginning of 2026. So this is the right place where we can discuss and share. So the last 6 months, I had an opportunity, not me and many of us had an opportunity to hear the views of the honorable judges of the Supreme Court from a very close quarter. I'll not say in this seminar and conferences, but in a small gathering where judges have expressed about their concern, about their deep concern, how to handle the artificial intelligence. And this concern was largely because of the cases which they noted in the brief, and they found the cases which were cited actually not existing, or even the paragraph which was cited, it was not relevant. The reference of case was so lot of issues were courts were encountering in the highest court of the country, that is the Supreme Court of India. So they have been thinking how artificial intelligence can damage the legal practice. And this is the view of views of the honorable judges of the Supreme Court of India. And recently, I also like to, I'm sure some of you may be aware also, that should be also part of the discussion, where the Supreme Court of India has recently come out with the regulation for use of artificial intelligence in Code 2026. It's a draft which has the Supreme Court has prepared, and they have covered a lot of things on that particular. So I think these regulations, in case if you have, otherwise I'll share with the Nayan Murthy, all can discuss on this particular. I have not gone through that particularly, but it has number of sections which comes around 57, which talks about the number of aspects which can be a starting point. It talks about the principles to govern adoption, deployment, and use of AI systems in courts. How courts has to use it. Then permissible and prohibited. What I have been thinking about the second chapter, third chapter, which talks about what is permitted, by what courts should permit and what courts should prohibit. That is there. Then the fourth chapter, which talks about the policy making and institutional mechanism. And the fifth chapter, oversight, audits, and incident management. Sixth chapter, procurement, data protection, then capacity building, grievance redressal, miscellaneous. So the entire this draft regulations which Supreme Court has prepared, where the Honorable Justice of Supreme Court and also earlier High Court, but now he has also moved in the Supreme Court of India. they prepare the regulations, which very important. And so we need, these are the aspects. So they have also talked about what has to, so two the important part, is permissible and prohibited. What has to be permissible and prohibited under the artificial intelligence is there. So this is one side where court is already started working. A regulation has been drafted and it has been placed on the public domain for seeking their opinion, and people will give their opinion accordingly. Certain modifications will take place, and then the regulation will be adopted. So means the challenge which has been posed in last 2-3 years or 4 years maximum, we see the transformation in the legal education. This is the first part which I say that code. When we come to the university system, many of you may be surprised and many of us are already aware, without using a single paper or pen, writing a single line, one can submit thesis, one can submit distinct from other species, that is the ability to think, ability to judge. So we have intelligence. So human intelligence should not be sacrificed at the altar of artificial intelligence. The more we use, the more we become slave of the artificial intelligence. The computer has almost reduced the students' capacity to write an answer in the examination when they have to write in the pen and paper. So it's become little bit we are seeing the impact of technology step by step, how it has overtaken all of us. It's not the artificial intelligence has jumped all of a sudden today and then we are talking about artificial intelligence. It has revolutionized. In India, if I say from 1998 when come the first time, the way of teaching, learning, everything has been transformed greatly in the past. I take you from here to the another area where artificial intelligence is being used uh, uh, in time of conflict, and that is very important, which we always see. Today, a small state can powerfully challenge a big state if they are technologically advanced, technologically sound. Like Ukraine is currently threatening, and that some way of late Ukrainian has demonstrated that they have a capability much better than Russian when it comes to the drone and technological aspect. And they are putting, you come to the term, otherwise we will destroy. We can. So the traditional notion of warfare has gone almost. It's not the military capabilities, how many tanks you have, how many soldiers you have, standing army you have. But now technology plays very important role in the war. So this scientific development, why I'm mentioning this, see, people were aware the future will be something different. How to regulate? So today we are here to regulate. How to regulate and use. How deployment, how using of technology, regulating of the technology in the legal education, in the code, and other aspects. So we are debating, discussing more on we are not saying complete prohibition of technology, complete banning of the artificial intelligence in the university educational system. So we are not here to discuss, and that is not possible also for us. So we are trying to find out a way where we can integrate technology with the legal education, technology with the courtroom technology. So we are exploring to find out a way out where maximum benefit of technology can be utilized, and same times the traditional method of workforce should remain effective, and that is the purpose for this. So no way we are we are encouraging or we fight, we struggle, we come on the street for complete prohibition of the artificial intelligence because it affecting some way human intelligence. So that is not like possible, and that we have to accept, and we are saying. So we are just saying we are studying, we are working hard to how to integrate technological development in the existing model of legal education or legal framework. That is the idea we all are here. So coming back to the scientific development, so when the knowledge of warfare, if I take you to if I take you back to the use of artificial intelligence in modern days, particularly in the time of the conflict, particularly in time of the warfare. So what we are witnessing, that the law which was developed, laws regulating to the warfare, which was developed in the 19th centuries and then subsequently in the 20th centuries, whether that technology and you cause damage to another, if a state A use continuous technology, artificial intelligence, automated weapon systems without man, although it's like no firing is going on. So who will be held responsible? So these are the questions also coming up in different areas, not only in the room or classroom, or rather every area has been affected due to the artificial intelligence. So here the fundamental principles remains valid. So fundamental principles are principle of distinction, principle of neutrality, principle of distinction, principle of proportionality. So you can't, if you have been hurt, you can't cause huge damage to another state. So these fundamental principles remain relevant today. The traditional idea, the fundamental principles of distinctions in time of warfare, principles of proportionality can be always used in the domestic context also. So these fundamental principles remain there. So accountability of the state can be fixed on the basis of the damage caused by the state to the another state. And that has been answered some way effectively under Article 36 of the Additional Protocol 1 of the 4 Geneva Convention. So to just give you an idea that laws regulating to modern warfare is primarily governs through the 4 Geneva Convention 1, 2, 3, 4, and subsequently these 4 Geneva Conventions were supplemented by the 2 additional protocols, Additional Protocol 1 and Additional Protocol 2 in 1977. So we found an article which talks about the scientific development and state's responsibility. So it says in a very one line, scientific development, if you use for any purposes, then the state will be, if it causes any harm to the another state will be held responsible for that. So some way, use of technology, use of artificial in time of warfare, state remains accountable under the traditional modern international humanitarian law and even evolving modern international humanitarian law. States become accountable to the parties. So that we see. So this law of warfare has taken care of the artificial intelligence almost 50 years before. Today we are in 2026, but this concern has been expressed under the 1977. Some way, some gray area is there in number of fields that is very concerned, and that is there. Today what we are saying, then when our students go to the law firm, I think all schools law they join, they just give a product. They say you don't need to search or draft anything. So we prepare to give you. So the company is giving. So they're using law firms, and that is the big challenge. Law firms have started using artificial intelligence in a big way, not in the country, outside of the country also. Even the lawyers on their own, some eminent lawyers, they started using. So the problem lies somewhere else. So artificial intelligence, it search through the algorithm and then find out whatever is available. But that it will never able to give a complete picture. What was discussed, what was referred in the judgment of the Supreme Court of India on on a particular issue or particular case. Take an example. If I say artificial intelligence, what it artificial intelligence will give you? It kind of this some kind of secondary sources which are circulating in the online, which are available on the online. That can be culled out. If I if I give you an example of some interesting case, uh, and that I keep on citing because I use the human rights courses, even the other courses I try. The case which some of the cases are very interesting, where we have seen that how court has looked into important aspects. I'm giving you an example of the case of Chandrima Das versus Chairman Railway Board versus Chandrima Das, which was decided by the Supreme Court of India. I think AIR 2000 SC 619 or 617, something in the 2000, by Justice Sagir Ahmed and Justice R.P. Sethi. The two judges were there. The case I found very interesting, and that is why I am mentioning here. But artificial intelligence will not be able to find out what we are like, what we can say to our students in the classroom. Artificial intelligence can say one thing, that the right to compensation is also right to compensation to a rape victim is granted by the courts, even in the case of a victim was a foreign national. So that may be good. The algorithm will come, and then artificial intelligence will produce before you, and you will use in your classroom. In all probability, it will miss how court has arrived on that particular conclusion, how court has written 10 to 12 pages discussing about number of things, how the defense lawyers argued, how the counsel for the victim argued in the courtroom, and what court has arrived, ending with granting the compensation. So principles developed, the court can grant compensation to foreign national. But the entire pages, 10 to 15 or 30 pages, court discussed. So what court discussed in the case? Court discussed, so like the counsel of the defense. No, the counsel of this is the petitioner, that the chairman of the railway board, when the railway board opposed the high court decision. So they argue, we are not against. They argued that the foreign nationals are not covered into the part 3 of the constitution. So the court answered that question, and you all know, I don't need to go court what court had said, and you are aware. Then they said the victim can seek compensation under the tort law, because there is no provision under the constitution for the compensation. Court has, and then try to make between the counsel for the petitioner for the appellant was based on the foreign nationals are not entitled for the remedies available under the part 3 of the constitution. One part. Second, she can seek the compensation under the private law, not the public law. So court discussed about, so I'm just suggesting 2, 3, like, no, so as a teacher, as a student, what we can learn from there, which artificial intelligence will not be able to feed us. So when you read yourself a judgment, you come to the number of points. So court has elaborated about the principle of distinction between the private law and public law in a very subtle manner, in a very elaborate manner, nicely made distinction between the private law and public law. Court also talked about the doctrine of what we discussed, constitutional tort, which court has discussed in the case. This is the first part in that. The second part in the case, which is equally important and which gives us some more idea about some other things which are equally important. What court had said, the second part. The second part court says, while deciding a case where a victim approaches court related to the seeking a remedy in cases of violation of fundamental rights, the court examines cases of violation of human rights. What court had said on that in 2000 on 2 grounds. The first ground, they said the domestic laws based on the constitutional jurisprudence. So essentially we go into the precedents, stare decisis. So we look into the case domestic law based on the constitutional jurisprudence. So that's perfectly fine. This is the fundamental law. They look into how court has in earlier decision. And second, they say the human rights jurisprudence. The court has added a new element of this case, and that has become its very interesting. The second element, court says, it's a human rights jurisprudence based on Universal Declaration of Human Rights. Universal human rights jurisprudence based on the Universal Declaration of Human Rights. I think I say human rights jurisprudence based on the international human rights normative framework. But court was focusing human rights jurisprudence based on the Universal Declaration of Human Rights. Court has also said the Universal Declaration of Human Rights has become moral code of conduct for each state party. So it has used both international law and domestic law when it comes to the addressing violation of human rights and granting compensation. So these are the few points which I say here. When reading a case study, when you reading yourself, you have not used technology. You learn something much deeper and which remains with you for many years in the classes and everything. So because we have used our brain, so never allow. Human intelligence should regulate artificial intelligence, not artificial intelligence should regulate human intelligence. So you are master. You should not become slave of the artificial intelligence. You should not think about the algorithm. You should not be like, why we are contemplating, why we are discussing about the legal, the courtroom, the classes, all challenging. We are master. We have to remain master. Our position is secure. But we are just saying if something is coming up in a big way, we are willing to make a way. So we have acquired the mastery. You all have learned. Many young students, teachers are going to become future teachers. So they have worked from for 30 years or 35 years in their life. They learned something, and suddenly something has come and then allows you to use it for your beneficiary, and it also allows you for causing harm to yourself. I don't need to study. Now I will make PPT. Now I will make all these things. Whatever is there for the class, I'll ask PPT, will prepare a PPT, everything is ready. But in the process, your dependency will increase. I keep on saying when PowerPoint was introduced, PPT. So every time you say PPT, you bring your PPT, you share your PPT, and you believe the teachers who use extensively PPT, PowerPoint presentation, if they use, and when they go in any seminar and conferences, when they are invited for seminar and conferences, before going into the seminar and conferences, they will coordinate continuously with the organizer. You ensure that even online, my PPT is shared properly. Because they believe. So I keep on saying, when PowerPoint, if power goes, that presenter should also simultaneously loses his power. So if he enters and says there is no power, there is a failure, the technological failure, he becomes restless. He says, I can't make a presentation. Because you relied on PPT so much, you stop thinking. So thinking is fundamental in human being. Intelligence is a very integral part of our existence, and it converts in the knowledge wisdom. Gradually, the more you read, more you study. So you never should think about if somebody is being controlled. It's not very or controlling. We have to counter it. We have to fight it strongly with our system and say, we have to, how far we can use, minimizing the use of technology, not for yourself, also for the students in your classroom, how to discourage that, see how much damage you are going to do. If you ask somebody, just recently in one of the agitation, some students were there on the street of Jantar Mantar. So now media people are also very alert. They said, why you are here? What is NEET stands for? What is the NTA? You are agitating, but you have no idea. Then he said, wait, I'll just in the I'll just do this in the there. But earlier, we had a sound understanding of the contemporary development which are taking place. And that sound understanding was possible because every day morning we learn from our parents, our grandparents, reading a newspaper was a regular religious activity for the in a civilized society. The early morning you will start with whatever language, Hindu, Telugu, Tamil, whatever the language. Now you see, and that is like a disciplined manner. So when your day begins, once you are out of finishing everything, every day is routine aspect, used to spend some time on the newspaper. Now you feel news are available on the social media. So whenever you have time, you read, or otherwise you cannot. So what you are reading just a gist, just a few lines, because this also reduces your capability to read. The internet has reduced our capability to go deeper in this subject because your answer you get quicker and then you take in the that. So you have not gone on this subject much deeper which a scholar is supposed to understand. And that is how you have to encounter. I gave you an example. Artificial intelligence will not be able to give you all these details which I have said to you. If you ask, what is the essential, principles developed in the case of Visakha judgment, it may give you some idea, but it will not give you the browning point which you can acquire only by reading, devoting time in your, sitting before the computer. Of course, you read online. I'm not saying you have to carry books, you have to take you have to sit in the library, but develop an habit to read, summarize, analyze, and think. To read, summarize, analyze, and think about critically thinking what are the points, why it has been there, and that as a lawyer, as a law teacher, you become a critical. That will motivate your students to come in the class. That will force, something is there. If I give you an example, artificial intelligence will give you an answer. Now the current crisis is the political crisis, which is going on in the case of the Tamil, in case of West Bengal. So I read yesterday some lawyer is advising, no, the new group cannot be created, the party cannot be divided. After the 91 constitutional amendment in 2003 and regarding the 10th schedule. So I was also wondering what the lawyer is saying of the political parties, a merger, a new party cannot be created from the mother party. That is true. But who is the original party that still exists? Like take the Shiv Sena example. So I said, why they are talking in 2003 when Shiv Sena was divided in two parties. So what happened? The original, who is the original? Who can claim the name of the party? Who can claim the symbol of the party? So what 91 constitutional amendment says, there will be no two Shiv Sena, there will be no two TMC. But who will remain original TMC and which party will remain original Shiv Sena? That remains there. So it's not this separate party will create TMC 1 and TMC 2. So there is a possibility. So who will decide? Election Commission will ultimately decide, and that can be challenged in the court. That is altogether different history. But Election Commission will decide on the basis of overwhelming support on all the levels, on the panchayat, peoples, and everything. And they said the original claim, the original party is Shiv Sena, headed by Eknath Shinde, and then other. So symbol and everything has gone to the new party, which was created by Shiv Sena. So you see, this is the, you started thinking, how lawyer is also fooling a political party. So question is the original TMC. Who will be which one will be the original? The original will be headed by the Mamata Banerjee or Rituparta Banerjee or Kapoli Das in the Lok Sabha. So this has to be decided. So the answer we have that Election Commission will determine and decide which is the original political party, and that has been decided. So there is nothing it has not stopped. The defection, so anti-defection law will not attract If a party divide, a party split with two-third majority, a new party, so the anti-defects are. Then the original party, the question of the original party is there. We don't know how far artificial intelligence can go and find out the answer of these questions on its own. So as a teacher, what I keep on saying, we also I always we also prefer, it's not, we have mastered everything. So we always think about, when you try to understand, you try to go deeper in this subject, in the, whatever the subject you teach, don't believe on the learning through the in the online mode, or using artificial intelligence is there. But I have also uh, said that we can't stop with the development which are I may personally I may not use for 10 years to 15 years, whatever time we have. Young teachers who has 30 years, 40 years to go and then learn many things. They have a different way. They are going to face bigger challenges in the classroom, in the method of teaching, and lot of things. Mainly, a new pattern, fortunately, it has not entered in India, and I was surprised when I was talking to my friend just couple of days back in foreign university, the traditional style of teaching has more or less disappearing. Classroom-based teaching is almost different. So only the seminars are, so earlier classes were divided in Australia, in Europe and others, lectures and tutorials. We have also lectures and tutorials. We also follow more or less lectures and tutorial in the classroom, yes, and we go accordingly to teach in the classroom with the this idea.
नहीं sir.
So what they are doing, lecture has gone, almost disappeared. So students are not required to come to the classroom. They pay huge money. At least we are better till now. What they said, after COVID, teachers upload their video, the 15 minutes video in the and then the student learn from sitting at home. So campus is more or less lecture without lectures. Only on the small classes 20 tutorials, they meet their teachers, they discuss seminar and conference. But regular teachings are gradually vanishing in the Europe, and other method is there. We have been facing, and interestingly, we have been facing the same problem when the Sushant Rohila judgment came, and then the impact of Sushant Rohila was so huge that students decided the Delhi High Court saying we have a right to sit in the classroom because we pay huge amount of money. They accepted. Neither existing students or alumni, for any matters they go to the court. But the students community chose not to challenge the judgment. And even if the judgment has been challenged, judgment has come into the notice of the Supreme Court of India. It has come while dealing with the another matter. It was not directly on the judgment. So judgment was not challenged, but it was informed the court if there is a judgment is creating some problem in the college. And finally, in one of the judgment, court had said the paragraph 249, I remember, paragraph 249 of the impugned judgment will be stayed for the time being till we decide. So paragraph 249 of the Sushant Rohila's case is there. So why students? So we have to also ponder over. We have to also think over why students are not keen to go to the classroom. We should not be jumping and happy. So I think there is something, maybe students are thinking the classroom is not interesting. Why don't we put the question, why we have failed? Why students enjoying not going in the class? So these questions need to be put before us. Why? So we have to also innovate. We have to also revisit our method of teaching. We have to also see how the classes can be made interesting, where the students automatically comes to the class and wait for the teachers to come in the classroom. So we need to reintegrate the existing system, make it interesting, and apply new methods which can be useful for it for teaching in the classroom and also attracting. So there is a challenge. There is a challenge for us also. It's not necessary merely securing attendance will guarantee the students have been learning in the classroom. What we want, their intelligent participation in the classroom. It's not attendance. I'm not for the attendance. I think, okay, 100 days, 100 class students in the classroom, but if they are not in the classroom, they are physically in the classroom and they are mentally outside, it doesn't make a big difference. If they are in the class, they participate, they discuss, they raise questions, they ask something, their intelligence level keeps on increasing because class participation. Those are the points. It's not securing attendance 77% will make a law student a good lawyer. A law student can be a good lawyer without attending any classes, and that has, you have a lot of examples where people have not attended a class and they are equally bright lawyer in today's time. So I'm not in opposed of the classroom, but as a teacher, we have tremendous role to play and ensure that participation is voluntary on part of the students. So we have a mandatory and voluntary and secure the mandatory attendance, but they participate in the class there, and there again conflict between human intelligence. So they say, why should I go in the class, sit there when I have everything in my mobile, my computer, I know more than the teacher. So those are the points we have to think about. We have to work on that particular point and see that we develop a good habit is there. Let's, for the remaining few minutes, I say that is very important. I read on the Times of India much earlier in 2023. There was an article published in Times of India. So I just, by chance, I read by Akshat Jain and published in 7th August 2023. It's one editorial, it's a very small piece, but it gave a lot of points which I shared with you and I'm going to use for you this day. So then Akshat Jain wrote an editorial on artificial intelligence on 7th August 2023. And he said the need for ethical code, and then he talked about, he mentioned there is a science fiction writer. He wrote a science fiction writer, Isaac Asimov. So he referred a science fiction writer, Isaac Asimov, I-S-A-A-C, Isaac Asimov, A-I-A-S-I-M-O-V. So he referred science fiction writer Isaac Asimov, and so he saw the science fiction writer, what is coming, he foresaw what is coming. So he says, foresaw the dangers of AI, dangers of artificial intelligence years ago, and has proposed. So he proposed long time back, Isaac Asimov. He saw that what artificial intelligence will going to cause damage, and proposed 3 laws of robotics. So he said he proposed in his writing in his book. This meeting is being recorded. 3 law of robotics. So he talked about the law of robotics, 3 laws he talked about. And what this is relevant. And what I have said, I believe that we are on this same side. So he said, his first law says, robots must not cause harm to humans. So he said, whatever the intelligence, his first law says, robots must not cause harm to humans through their actions or inactions. So whatever we develop, it should not cause harm by actions or inactions. This is his first law. Second, he says, the second law requires robots to comply with human orders. So you remain master. What I have been saying, we have to remain master. So whatever the technology has to be controlled by us, but never ever allow technology to control us. So we control the technology. The second law requires robots to comply with human orders. Our orders need to be followed, except when such orders conflict with the first law. Except such order conflicts with the first law. So if we are giving some command and saying cause the harm, then that robot can also defy. The first law says by using technology, it should not cause harm, in any way. Second law says you control, as a human being you control. But when you control and you say, you comply my direction, and that direction may cause harm to the other, the robot should decline or artificial intelligence should defer. What we say is superior subordinate relationship, command responsibility, where a commander says, kill the soldiers of enemies. And that violates, killing an innocent civilians or killing innocent combatants violates the principles of IHL. So whether subordinate should kill and say because commander has given an order, the law says no. The order which is manifestly wrong, the order which is manifestly, if a teacher says in the classroom, you beat this student. So teacher commands in the class, respect, authority, everything. But a teacher says, you take this, stand up in the class, roll number 23, and beat brutally roll number 24. Can a student do that? A student has a right to defy. A student should not follow manifestly wrongful order of teacher. And that applies everywhere. The second says, you don't apply if order is wrong. So, and third it says, the robots to safeguard their own existence as long as it aligns with the principles of first and second. So for the good causes. So ultimately all three laws it talks about the good causes. For the best practice, for betterment of the society, the technology has to be used, it has to be balanced. So balancing. What we are saying, what is the Supreme Court also in 2026, what is prohibited, what is permissible. So what the permissible means, what is the, helpful for the society, helpful for the court, helpful for the litigant. Those things are permissible and that has to be accepted in there. The another important, so this is the, I just said, this is the, there are as a core principle before I come and end, there are 10 core principles which is developed by the UNESCO for a couple of years back, and that is 10 core principles lay out a human rights centered approach to ethics of artificial intelligence. So quickly I'll just highlight the 10 principles which I have mentioned, some of the principles I have discussed. So what are the core 10 principles which with centered approach to ethics of artificial intelligence. Ethics of artificial intelligence 10 principles. The first, proportionality. Proportionality and do not harm. The first principle, ethical principle in artificial intelligence is a proportionality and do not harm. That is the first proportionality and do not harm. I have discussed and we have understood the proportionality principle. We applied in the case of the warfare situation in the conflict time. So I said the fundamental principles remain same. That is the principles of proportionality. And what ethical principles are also developed by the UNESCO on later on. It talks about the proportionality and do not harm. So the first fundamental principles, I did not look into in that particular time, but in the context of conflict, I have discussed about the proportionality. So proportionality remains a fundamental principle both in ordinary time, domestic law, or international law is there. The second is the safety and security. Safety and security is so how to minimize that should be also addressed by the AI. Safety and security, that is equally important. The third, which is we keep on talking about, and also it has been decided by the Supreme Court of India, in the right to privacy and data protection. Whatever you do, data will not be protected. Whatever, we keep on fighting. It's a continuous like struggle. What judgment has been delivered in the Supreme Court, it will be more an academic. You just you want to know about any person, you get every information. The only way you may not be your information, less participation in the online will ensure your privacy. The more you participate, not the algorithm will understand what you are like, your taste, what kind of food you like, what kind of diseases you are suffering. So it will sense everything. The more you search, the more you surrender to technology. You just try. You start with that where about the diabetes, and every time the moment you open the number, what are the medicines, some guidance, every time you open your computer, the first thing will come, and you will start receiving messages, everything. So computer understand, artificial intelligence, the person requires some medical attention, some kind of, and not only that, that information will go to the medical agencies, doctors, everybody will come to know this such and such. Just I am giving an example. Today I saw that when I opened my email, the email said, Ease My Trip. So Ease My Trip, the online the portal for booking of the ticket, and that it says, the window seat is waiting for you. So window seat is waiting for. So my preference when I travel, always I prefer window seat. So now they understood is my, because many times I have preferred chosen seat is window. So that is saying the window seat is waiting for you. Means they understood. So my privacy is good. At least is my trip. Note is what kind of seat I prefer, what kind of meal I prefer. So this the notion of privacy, which I keep on saying with all conviction and belief, it's more an elitist concept. We talk about the privacy, data protection, we surrender. Privacy, how can you, physical privacy is not also possible in a country like India where 80% people are still without door and without windows, and there are a lot of issues are there in the country. You can't talk about the privacy, uniformly privacy. So privacy is due to economic reasons also, privacy is difficult to respect, and then of course technological also. Sudhirji, I will come back and take your question in 5 minutes. So that is the also. But anyway, in artificial intelligence, right to privacy and data protection remains is there. Then we have multi-stakeholders and adaptive governance of collaboration, that is there, and that talks about the basically multi-stakeholders and adaptive governance and collaboration. It talks about international law and national sovereignty must be respected in the use of data. So it's not the data is flowing. It's a so jurisdictional issue will also become an important in there. So there is the collaboration approach is important in there. Responsibility and accountability. The fifth point is responsibility and accountability is equally important. AI systems should be audible and traceable. There should be oversight impact assessment. Impact assessment, which we are distracting, we are trying to impact assessment, audit and due diligence mechanism in place to avoid conflicts with the human norms and threat to the environmental behavior. So before utilizing, we must impact assessment, audit and due diligence is equally important in there. The sixth is the transparency and explainability. It talks about the ethical deployment of AI system depends on their transparency and explainability. The level of P and E. So basically transparency and explainability. Transparency and explainability means P and E. The level of P and E should be appropriate to the context, as there may be tensions between T and E, other principles such as privacy, safety, and security. The seventh is human oversight and determination. Human oversight, member states should ensure that AI systems do not displace ultimate human responsibility, which we have talked about. Human oversight, human responsibility and accountability. You can't say it has been done by the artificial intelligence. So the human responsibility and accountability which we discussed in our day, that sustainability and the most important for us is a fairness, is a awareness and literacy. Awareness and literacy. So what we are doing, it's very important. Awareness and literacy is very public understanding of AI, and data should be promoted through open and accessible education, civic engagement, digital skills, AI ethics training, media and information. So ninth, we are doing in a big way. And then last is the fairness and discrimination. AI should not promote any kind of discriminatory practices. It should be social justice, fairness, and non-discrimination. I think I'll end here and the 10 points which I have highlighted. Some of the points I discussed when I deliberated upon the gender perspective, and we come to know that, the human accountability, human responsibility remains there. Proportionality is very important. Data protection are very important while using artificial intelligence. With this, I end here, and I request that in 2-3 hands were there. If any questions or something is there, I'll be happy.
Thank you, sir. This side, Professor Narendra Bahadur Singh. Actually, yes, I was raised my hand just because Honorable Justice K.J. Thakkar sir is online. So I want to formal introduction with you. I have an idea you both are a good friend, but on the
good morning, Lordship.
Dr. Anand.
Sir.
Honorable sir. Lordship.
So I have stopped my time. So Lordship, I have not taken I did not dare to cross that borderline, so I remained in.
So he is online, he is connected as well. I request.
Yes. Okay.
Sir, please unmute yourself.
Give me a second.
Sure, sir. Sure.
I am calling, sir.
In the meanwhile, I would like to request Dr. Prashant Kumar, sir, Assistant Professor ILS, Sri Ram Swaroop Memorial University, to formally welcome our distinguished guest, Justice K.J. Thakkar, sir. Sir, over to you. Due to some technical issues, Prashant sir is joining within few seconds. In the meanwhile, our distinguished panel speaker.
Am I audible now?
Sir.
Am I audible
as well? But
can you people see me now?
Sir, you are visible too. Thank you for joining us, sir.
Thank you.
Manoj sir.
Manoj sir, good morning.
Good morning, sir. Good morning, sir. Good morning, sir.
लंबा अर्सा हो गया नहीं मिले, लास्ट गोवा मिले थे before.
Thank you. I saw your name and I feel very happy that we are.
I saw your name and I told नरेंद्र जी के साहब को कीनोट एड्रेस करने दो. ये सब टॉपिक्स हमारे लिए AI वाला काफी नया है, but and then I thought that as it is my session, I was more relaxed. But then when I talked to him yesterday, he said, "Hey, आपको तो 1 घंटा बोलना है." Then I prepared the. Yesterday I was in Bombay with the judicial officers of Bombay.
Lots.
Thank you, Dr. Sinha, for enlightening us. Navendra ji, thank you very much. Unfortunately, मेरे लैपटॉप में नहीं कुछ 1 घंटे से ट्राई किया, but I could not join it, and so I have to join on mobile on this small screen. So you people may pardon me. But am I audible properly now?
Yes, sir. Yes, sir. You are audible. Before you proceed, sir, for the other participants, I would like to invite Dr. Prashant Kumar, sir, to formally invite you for this session.
I take your permission because I have to go somewhere. So I am very happy to see you today. I am happy to see you today. and we'll be in touch.
Thank you.
We'll remain in touch.
Sure,
Thank
sure,
you,
sir.
Very good morning, everyone, for your presence here. It is my proud privilege to introduce our chief guest for today. Is a towering figure in the Indian judiciary and human rights jurisprudence, Honorable Justice Kausal Jayendra Thakur. He is Honorable Chairperson of Gujarat State Human Rights Commission. Sir is Gold Medalist of LLB in Gujarat University and a PhD in Environmental Law. Justice Thakur began practice in 1987 and served as district judge and later elevated as Honorable Justice in Gujarat High Court in 2013. Sir has authored several landmark judgments under the Motor Vehicle Act and Arbitration Act and in constitutional matters. Sir has trained mediator, resource fellow with National Judicial Academy and a recipient of postdoctoral LLD from NFSU. Justice Thakur has been a pioneer in promoting mediation and legal aid through Lok Adalat. Sir, we are truly honored by your presence. May I request you to kindly address the gathering.
Thank you. Good morning, everybody. Thank you. Before I begin, I would like to have this into two phases, rather three phases. Pre-AI age and due process, algorithmic justice, now with the advent of the AI, and pre-constitutional era. Now, why this? See, this contemporary debate about algorithmic justice, I have never felt that there can be justice like what is known as 1 + 1 = 2. Therefore, according to me, algorithmic justice is basically a misnomer. Justice, to be algorithmic, has to follow the precedents. Algorithm means transparency of decision making. Now, how can you have transparency of decision making? It's as I have been many times telling that there can be algorithmic hooking. So, in one of my lectures, I told this, and the students started questioning, sir, वो कैसे हो सकता है? मैंने बोला, देखिए भाई साहब, आपके माताजी को उनकी माताजी ने रोटी में इतना नमक अपने घर में पड़ेगा. So that is what I call it as precedential going about. And precedential going about is akin to algorithmic justice. Why? Because judicial foundations, I cannot take a decision that no, I believe that inquiry report is not necessary. So that is against the due process of law judgments. And you have to have transparency of decision making. How will you have transparency? Once you have the algorithm before you. Pythagoras aa gaya, he is a good law today also. And at times what happens is algorithms with AI, I'm very clear about it, would lack human consciousness. And what you need in your justice is constitutional morality. You may have statistical patterns, but human sufferings, will AI be able to look into it? Say, for example, a motor vehicle case. You feed the things. AI does it. Fine. The principle, according to me, should be, as Professor Dr. Sinha said, human in the loop. Human in the loop. And we are supposed to govern the AI. Let it not govern us. Automated decision making is fine. But at the same time, that has to comply with what I call as constitutional systems. Once you feed the AI will also have to have what is known as constitutional basis. It will say if to the AI you feed something and don't feed that these are the principles of natural justice propounded in Maneka Gandhi. AI may or may not get that accountability. Say, for example, Supreme Court has been heavily coming on young lawyers who go about this ChatGPT or Beta AI or AI generated decisions. At times there are a lot of faulty decisions. Before AI came into picture in this last decade or so, there were similar concerns, as I call algorithmic justice is akin to relying on precedents. You build up the case on the basis of the precedents. I cannot say that I will not follow Sallah Verma's judgment because my AI says something else. No. See, I cannot say that administrative discretion vested in me is not to give hearing to the person because my AI says this. You cannot have that. The computerized records, the statistical data cannot be overlooked. Prior to the advent of AI, we will have to see the constitutional foundations in India on which justice was cradled. Say Article 14, classification, and as early as 1974 in Royyappa's case, where the Tamil Nadu government was not giving equality, the Supreme Court said that arbitrariness and equality cannot ride together. This paved way for the coming generations, followed by Maneka Gandhi reiterating that the procedure established by law must be fair, just and proper. And then comes the judgment of Ajay Hasya, 1981, that opaque algorithms cannot escape constitutional scrutiny because they are based on technology. See now, A.K. Kraipak is a very important judgment of 1969, where we have recognized the principles of natural justice. An administrative action opposed to natural justice, say for example, an automated order denying benefits or imposing penalties, could not have been done. And that has been frowned upon by the Supreme Court. You have to give reasons. Say for example, I'll give a concrete example of yesterday only. I was to give a lecture at the State Judicial Academy, Maharashtra. And I wanted the judges to go by what is known as a judgment landmark of 1962 in Gopal Motors. I fed the Google, they kindly give me judgment on Cobalt. Now before some time, I had downloaded the judgment of Gopal Mohammed. Google gives me everything on Gopal Mohammed. Now is this fair to me? Is this what I would like from an AI? The answer is no. But why this happened? Because it had an earlier feeding with itself and it did not bother to look into the new thing. And therefore the human mind which thereafter saw it, that मुझे ये तो नहीं चाहिए था भाई. I did not want to do this. And therefore that is the human reasoning which your ChatGPTs and AI algorithms will not look into it. So at times, the algorithmic decision, say for example, Salah Verma, I have distinguished it in 3 matters. And thereafter came, it is an algorithmic judgment as far as others, some of the aspects are concerned, but you cannot have a copybook algorithmic judgments. Now, I tell ChatGPT, this is this, this is this. It doesn't give me reasons. I pronounce the judgment. The High Court is going to frown on me. Howsoever correct my judgment may be, you have to implead what are known as recording of reasons. You can't have black box. Administrative fairness has to be there. Ramanna Shetty's judgment on International Airport Authority and S.N. Mukherjee are 90s judgment which frown on unreasonableness. I feed something to ChatGPT. It gives me a tailor-made judgment like they did it in Kharak Singh. I tell it that Kharak Singh wale judgment किस में follow हुए वो दे दीजिए and I feed it in my judgment. Fine. Let it add to what you want. It has to be for your benefit. Data protecting and digital governance is good. That has been accepted in 2005. The United States also, before AI came into picture, had its own judgments on due process of law. Because this term has come from them and inherited by us post-constitution. 1970s welfare benefits cannot be terminated without hearing is a judgment of the effect of their Supreme Court. And a recent judgment of Matthews versus Eldridge, procedural due process. We have also been using algorithmic justice for 4 due process questions. And therefore, what I would suggest is that we have been following United Kingdom. Ridge versus Baldwin is a very important administrative law principle which is enunciated even in the books of Justice C.K. Thakkar in his administrative law. Ridge versus Baldwin is a 1964 judgment, and natural justice in administrative law. Can you say, no, Ridge versus Baldwin is a 1964 judgment. AI says don't follow it. You can do away with natural justice. Then it would be bad. Even if judicial review, which is based on irrationality, will be bad. Human right approach is a must. And to feed AI that please give right approach, your judgments are going to be wrong. And therefore, what I would suggest that we should feed AI properly so as to have algorithmic justice. Algorithmic justice, which is of non-arbitrariness, fair procedure, natural justice, duty to give reasons, transparency, equality before law, rule of law, and informational privacy and data autonomy. Now, as I would not, there were 15 minutes which I had allotted to the present scenario that we are not safe, even if you do something, but that has been covered by Dr. Sinha. So I am saved of that. Now, what is the current situation in 2026? We don't have any direct Supreme Court ruling on AI, but Supreme Court has given us certain guidelines. And what I would say that we have to adopt 3 reforms, basically, which would be necessary for us. 3 reforms. One, the India's path forward cannot be based on pillars which are likely to fall, The AI decision will be frowned if the algorithm fails to adhere to any of the principles enunciated pre-AI. So, the due process can be reimagined, but it cannot give way to the earlier principles. The wooden gavel has given way to digital code. You can't bang the desk with a digital code. You have to have the gavel. So gavel cannot be, as I say, gavel was there, will be there, and it has to be a sacred constitutional shield to even this due process. The machine has to be fed properly. And as I have been telling time and again, there are wrongs which even the grave does not bury. And we being a democracy, as said by John Lewis, I quote, a democracy cannot thrive where power remains unchecked and justice is reserved for a select few. Ignoring these cries and failing to respond to this movement is simply not an option. Peace cannot exist where justice is not served. Unquote. Why this? See, if you want to heavily rely, heavily rely only on what Am I audible?
Yes, sir, certainly you are audible.
Definitely.
Okay. So, the core due process questions cannot be given a go by even in the days of algorithm. Enacted by what I call as AI. And therefore, say bail predictors by AI may or may not prove fatal But at times, what I call is, you should be aided by it and not governed by it. So the example is under Motor Vehicles Act, sentencing policies. And how will you apply this AI again on your brain? ChatGPT से सब ले लिया. सर ये तो मुझे नहीं चाहिए था. So where do you go? Will you give it again to ChatGPT? No, you'll have to go to your legal digest. You'll have to go to your precedent. And you'll have to go to the legislative intent, the evidence law. And therefore, it's like a recipe for food. Your judgment or your justice is, what is an algorithm according to you? According to me, it is a step by step. You build your castle on the rules or instructions. Algorithms under algebra are followed to solve a problem or complete a task. And it is like you have the recipe, but you don't have the chula to have it. What are you going to do? Earlier, when I joined judiciary, there were no computers. Leave apart computer, in my first meeting on AI, one of my honorable judges told the High Court, सर ये सब बातें छोड़ दीजिए, पहले हमको आप एक तो कीजिए कि हमको इलेक्ट्रॉनिक टाइपराइटर तो दे दीजिए. You have to have data autonomy. You have to have autonomies and information privacy. In the end, all these cases establish that technology cannot become a constitutional black box. And every exercise of public power by a human being who is a judge or a judicial officer or a quasi-judicial officer must remain transparent, accountable and subject to judicial review. Say for example, algorithmic justice is being done today under the Motor Vehicles Act. Can I say I will not follow Salah Verma and Pranay Shetty for future prospects? When my AI says, these judgments are old, they are 2017 and 2009, let's think something else. Okay, fine. Go to their formula. Apply your rationale. Step by step. Because, as I told in the beginning, algorithm is nothing else but is step by step. Say under civil procedure also, interest calculation methods, reason remission. कहते जेलर से कि मैं तो दे देता हूँ, जाइए आप. See, algorithms will have to base their judgments on Menka Gandhi's judgment. And what do you call justice? What is justice? Equality, transparency, and reviewability. And therefore, as I have told, algorithms by AI, not by humans, will lack consciousness. So, you have to bend them with constitutional morality, and then only they will be satisfying the core of due process, and that will have to be protected. Say, for example, unfortunately, law teachers will agree with me. We earlier were considered as gurus. Now AI has made us service providers. I am myself a lecturer. I was a lecturer. I have been taking regular lectures at the National Forensic Science University. Now why this? Why this? जो बच्चे पहले किताबों में पढ़ के लेक्चर सीरीज देखते थे, मुझे याद है यूपी की लेक्चर सीरीज हम लोग 1987 में पढ़ते थे. You may feel that why I am telling this, because there were students who are there with us, and I am trying to inculcate in them the art of hearing to the lecturers, and not only simply rely on what I call as Google Baba. So you just try this. You feed Google Baba with Dr. Manoj Sinha, Dr. KJ Thakur, and misspell Thakur to Thakkar. You will get all wrong information. So had it been AI, I would not have pardoned him when he called me Thakkar, because I still believe that I am opposed to the Shakespearean thought of what is there in a name. There is lot in a name. There is lot in a name. And algorithms will be prototypes, you know. You feed it something, it will give you something else also. As I told you, Gobart gave me Gohal Mohammad's judgment. Thank you for that AI. But at times AI is good. But it should not sit on our minds. We should be governing it. That is all that I want to tell today. In the age of AI, it is not technology which will have to govern the law. The law will have to govern the law. Why? Technology has to be fed by what is law. There has to be digital rule of law. Algorithms are shaping human freedoms. And Constitution has always got a control over digital power. Automated judgments have to give way to a well-thought judgment penned by lawful, proportionate and accountable reasoning. AI cameras are monitoring us. I was recently in London. There you have CCTV cameras on the road and people are really very scared. I think we should also implement that so that at least road traffic sense is brought into us. I am really thankful to Dr. Saab for giving this opportunity to me. The myth is that AI has to be unbiased. Artificial intelligence has a risk level of, I won't say 8 out of 10, but 5 out of 5. 5 out of 10. Why? Say you feed algorithms. I'll tell you what algorithm did bad to me. It's a practical example without AI. I was a judge in the Gujarat High Court. And in Gujarat, if a person is booked for narcotics or as a gangster, the severity would be such that we would not grant bail. Now this was an algorithm precedent set in my mind. I travel, I am appointed as a judge of the Allahabad High Court. I am given that roster. A man comes, तो मेरे सामने 4 गैंगस्टर के मुकदमे हैं और चारों में मुझे बेल मिला है. अब ये 5वां लगा दिया है. So you see my algorithm, my AI in my mind, that this man cannot be released on bail. Why? My algorithm said that he has breached the terms and conditions that he will not be committing this offense again. Now I was told by a colleague of mine, it is not so in UP. Even in husband-wife के झगड़े में भी वो लोग gangster लगा देंगे. So I went to the case law, I went to the facts of the case, and then granted bail to him. So this is algorithmic justice. With your mind AI, not a computerized AI. So you cannot permit this because AI, you permit, you fed a evidence to AI and don't feed the cross-examination. What happens? Can you decide the case on that? Please don't do it. Algorithms will have to explain judgments in the language which my trial judge understands. I am not criticizing bombarding languages. I would not like to read a novel where I have to sit it with a dictionary. So I would prefer a novel or a judgment which is lucid, which I can understand. See, AI does not think like a human philosopher. And the moment the data is flawed, what happens? Thakkar ka thakkar dala, kya karoge? You will get that Thakkar has written 5,000 books. I have not penned a single book in my life, except my 2 theses and some articles here or there. I would request the audience to put questions to me if they feel so, as there can be no secrets. When human rights are the line, we must demand them in their own way. Yes, Anand sir.
Dear participants, you may ask the question. It's a question hour session, open for all. Faculties, scholars and academicians.
And sir, till the time people come for the question, I have a small question. Sir,
Yes,
I am a teacher teaching students, and the biggest challenge that we are facing with AI is, this was also a question to be posted before Manoj sir. He himself is an academician, he would have answered it, but even you would have, when you started your session, you started that Supreme Court has had this new young lawyers, they are strictly coming strict on that. You are relying on a AI source of information and referring to the judge.
आपका क्वेश्चन क्या है मैडम? आपका क्वेश्चन क्या है? What is your question? I am not able to get your question. Your voice is breaking.
Shruti ma'am, there is a slight disturbance in your voice. Kindly mute and unmute yourself once again.
Just so my question is, how can we face the challenge and discourage young students and lawyers to be mind cuffed by the AI? So
See,
what
Yes, okay, I have understood your question. You can't do that in this era, but you have to inculcate a feeling in them that fine, as I told, you go to AI, but at the same time, you will have to re-verify it from the law journals, the authentic law books, like say for law of torts, you will have to still go to Vatarlal Divatlal or Samand as edited day in and day again. And see, they are overwhelmed with all these Google business, and the chat GPTs and what they get on Manupatva and all. So they would be, but they have to re-verify it. And that is the only way you can re-bring it to them in this era. That is the best way.
Thank you, sir.
My pleasure, my pleasure.
Other participants may ask their question.
I think there are no more questions, so I'll end with a conclusion.
Sir, this is another problem of the AI era persons. They are only hearing the session. Sometimes I push them. Why not you ask? It means you are not. It means you are not hearing seriously.
नहीं हियरिंग का नहीं होता है, ये मैं हमेशा कहता हूँ, हर लेक्चर में कहा है, आप गलगोटिया में तो भी मैं कहता हूँ, जब प्रश्न नहीं पूछा जाता है तब ये दो ही किस्म के लोगों को प्रश्न नहीं होता है, एक मेरे जैसे जिसको कुछ नहीं आता है फिर भी सिखाने आ जाते, और दूसरे आपके जैसे जिसको सब आता है ये सोच के कि गूगल के पास सब जवाब है.
जी सही सर ठीक सर, कंक्लूड करें प्लीज.
I'll conclude and thank you very much for giving me this opportunity. Let us hope we meet in except online in future.
Offline mode, definitely sir.
Offline. Thank you. I may be permitted to leave. Thank you.
Okay. Thank you, sir.
Thank you.
Dr. Anand.
I would like to invite Shruti ma'am for the formal thanks to our honorable speaker.
I think Juhi ma'am is.
I am here, sir.
Juhi,
Thank you.
Yes, please.
Thank you, sir. I'm equally thankful to Director sir for inviting you here and so that we can hear you out. This was my first chance hearing you and it was amazing experience, sir. And I hope the overwhelming experience was from the other audiences too. You have actually the together to get the insight very beautifully. जैसे कहते हैं हमने पिरो के दे दिया है आपको, उस लहजे में मैं कहूँगी कि बहुत ही अच्छे से it was communicated to us. We and क्योंकि हमारी यहाँ पे audience UG से PG हर strata की है, so the way you have put in, it would have consumed equally beautifully by the audience. So thank you so much, and we look forward for hearing you more often. Thank you, sir.
Pleasure, Shruti ji. Welcome. Thank you. May I now leave, Devendra ji?
Yes, sir. Thank you very much, sir. Thank you for your blessing.
My pleasure.
Thank you, sir.
All the very best for your further.
Yes.
Okay.
Thank you.
Thank you, sir. Thank you, Shruti ma'am, for the beautiful thanks to our distinguished guest. Now, moving forward, we have another distinguished guest, Dr. Juhi Arora, will be joining. Already she has joined our national conference. So her formal introduction will be done by me. Advocate Juhi Arora is the founder and esteemed.
Anand ji.
जी सर.
फॉर्मल इंट्रोडक्शन से पहले मैं थोड़ा सा कुछ अपनी साइड से थैंक्स और वेलकम करना चाहूँगा.
Sure, sir.
So I would like to thanks from my inner side because at the 11th hour, Advocate Juhi Arora ma'am are going to blessing our conference participant because of the non-connectivity of Prashant Singh Atalji. He is in Bhutan and he is trying many times, but he is unable to connect with this conference. So at the 11th hour, ma'am is sharing their time from their busy schedule. So I would like to again salute to ma'am and then you formal introduce ma'am. Thank you.
Thank you, sir. Advocate Juhi Arora is the founder of esteemed law firm Juhi Arora and Associates, which operates pan-India. We welcome you, ma'am, to this national conference. She also serves as the managing partner of the DRF Conflict Management Solution. She is presently compiled in panel as a counsel for the central government before the Honorable Supreme Court of India, as well as the counsel with the Delhi High Court Legal Service Committee at the Delhi High Court. Advocate Juhi Arora is a certified mediator by the Delhi Disputes Resolution Society DDRS, Government of NCT of Delhi, and also has been selected as a mediator by the Honorable Supreme Court of India in collaboration with NALSA. She is an active member of the leading professional bodies, including the Associated Chamber of Commerce and Industry of India, the International Council of Alternate Dispute Resolutions, and the Delhi Arbitration and Conciliation Council. Beyond her legal practice, she is a regular debate and TV panelist on a reputed national news channels where she shares her legal insights on pressing issues. She has mentored and provided internship opportunities to thousands of law students across the India. In her recognition, outstanding contribution to the legal profession, she has been conferred with the multiple awards, including the Emerging Lawyer of the Year 2022 by the Indian National Bar Council at the Constitution Club of India and the Ashoka Samman Award 2024. Today, in recognition of her outstanding contribution of mediation and legal aid, Ms. Juhi Arora is being conferred Capital Award by the Justice Ujjwal Bhavan, Honorable Judge, Supreme Court of India, in the distinguished presence of Justice A.K. Patnaik. With this formal introduction, I would like to hand over today's proceeding onwards to the Juhi Arora ma'am. Ma'am, the virtual dice is yours.
Thank you so much, Anandji, for a great welcome, and Narendraji especially, who is a gem of a person. I've just met him few months back for a conference and for a collaboration with DRF. It has been exclusively a good collaboration with GLB University. All of the persons who are at place at SRM University are very much well-to-do, well-placed, and very much down-to-earth people. I would say SRM University is really doing great. So thanks for inviting me once again, and it is my pleasure to be at the 11th hour, sir. It is my pleasure to be associated with SRM University. Anytime I would try to make myself available as much as I can. And it was a pleasure also to hear Justice Kaushal Thakkar sir, who has just given us a brief introduction and overview of the algorithm of AI and how justice is conferred when we are using in the world of AI. And also, it was a great hearing of that particular session. So I also learned, since we all believe that we are a law student till today. हम सब जानते हैं कि आज भी हम law student हैं. I myself admire and I self consider myself as a law student, because this is the field which is never ending learning process, and it is very challenging. Every day we get some of the other matters who give us that window to peep out of our own mindset and to think something out of the box. It's all because of something which we are inculcating from the day one when we are in law school. So there is a judgment by the name Manish versus Sandhya. I would start with that. You can also see on the Google. It is a precedent and it is a reported judgment wherein I appeared for the husband sides in that particular judgment. That time, why I'm quoting this judgment here, because I want to make you understand that whether you are in the era of AI or you are not in the era of AI, the out-of-the-box thinking of the lawyer should also accompany you. So, to be a successful person. In that particular case, in 2016, when the judgment came from the High Court and it got reported by the double bench, it says that the husband, my client, got an divorce, divorce on the basis of irretrievable breakdown of marriage. My fellow listeners, I would say that this particular ground, the irretrievable breakdown of marriage was never been any ground in Hindu Marriage Act that time also, and even today also. Everybody knows who have read the Hindu Marriage Act. So Section 13 of divorce, which give us some grounds, doesn't have this ground. But due to the precedents of the Supreme Court, which I managed to make, and the facts of the case, which are clearly connected to those precedents, the court was somehow being convinced by my arguments and by my take that the precedent was being passed in the matter wherein this matter was reported, and my client got a divorce on the basis of irretrievable breakdown of marriage, despite not being a ground in Hindu Marriage Act. So why I am saying this is like, in 2016, there was no name of an AI that time. Still, I had out of the box thinking. That is why we were being able to get a divorce for my client, and it got reported. But as of now, if we are in the era of AI, we are not actually using our mind. We are everything depending upon the Google, we are depending upon the different apps of the AI, which suggests that you just put the draft and it will come with the proper judgments and everything. It's a whole cooked, some food you will get. But my friends, I would admire this, you would admire this. The fact is that people are actually not using their brains. They are totally depending upon the AIs. It is always said that human technology cannot be replaced. Human minds cannot be replaced. AI is a friend of us. AI can help us, assist us, but you cannot replace your human minds with totally AI. There are so many petitions which are drafted from AI. There are so many apps which are coming for AI and coming for sale that which are free of cost. You're using, students are using and putting their whole draft and facts and making it in a proper petition. But trust me, whenever you will argue before the court, if the facts are not on the tips of an advocate, and if the judgment has not been read properly by an advocate, then at the end of the day, you won't be able to satisfy the court that it is actually your case and you have had fully drafted it. So I believe that AI cannot replace human minds. I'm not against the AI. I'm not at all against the using of the AI, but I'm against the dependency of the AI. We should not be dependent on the AI. Young fellow students are totally getting dependent on the AI, and it is difficult for them to think out of the box because Google is already, the AI is already giving them the whole cooked some food, and at times that cooked food is raw also. As very well said by the Justice Thakur, that कई बार कोर्ट्स में हम जाते हैं, देखते हैं कि आपने पिटीशन बनाई है, उसमें दुनिया भर के आपने लॉ के जजमेंट्स डाले हैं, बट वो एक्चुअली वैलिड नहीं होते हैं. कहाँ से उठा के AI ने डाला हुआ होता है, and at times Supreme Court comes seriously strict on those petitions which are made by all these things, and the heavy cost also get imposed on these people. So please try to use your human brains, because everything is replaceable except the human brains. Human brains can't be replaceable. It is very not good to say that हम ये कहना हमारे लिए सही नहीं है. That tomorrow there would be an era जहाँ पे lawyers की जरूरत ही नहीं पड़ेगी. We can read many articles come like this, that आने वाले टाइम में lawyers की जरूरत नहीं पड़ेगी, एक lawyer का काम, चार lawyers का काम AI करेगा. See, to this effect I would say कि आप कितना ही AI use कर ले, अगर आपके पास वो human touch हो. At times the definition of the human touch varies from person to person, but according to me, unless and until the judgment carries that human touch, the human mind, it is not a wholesome of the judgment. It always carries some defect if it is not carrying all these ingredients. So at the end of the day, I would say we should welcome every change, since कहते हैं ना, परिवर्तन हमारी जिंदगी का एक बहुत अहम हिस्सा है और हमें परिवर्तन करना चाहिए समय के साथ. लेकिन उस परिवर्तन के साथ साथ हमें ये नहीं भूलना चाहिए कि भगवान ने हमें वो दिमाग दिया है, जिस दिमाग से AI को भी हमने ही बनाया है. So we should not forget that AI has been kind of a production from some human mind only. Not human minds have been produced by the AI. So that's all I would say.
Anand ji.
Thank you so much, Aruna ma'am, for such insightful address to the conference, and I hope the participants must take away some thought-provoking address at this conference. Her valuable prospects have substantially enriched the deliberation of the day and strengthened the intellectual foundation of our discussion. We remain deeply grateful for her esteemed presence and scholarly contribution. If anybody related to today's third session, any query, any question, they may ask. If anybody has.
अगर क्वेश्चन पे पार्टिसिपेंट को ये लगता है कि क्वेश्चन नहीं करना है तो इसको डिस्कशन मान लीजिए, क्योंकि टॉपिक वर्निंग है. अगर आप लोग कुछ बताओगे, कुछ जानना चाहोगे तो उस पे डिस्कशन होगा. प्लीज.
Anybody want or go for the further discussion on this burning topic of today?
I hope no one has a query, because someone is writing even in the chat box. No questions, sir. So please go ahead.
Okay, then this is a formal thanks to Dr. Arora ma'am. So after this session, we will be winding our first half of this national conference. Our technical session will start at 1:30 p.m. sharp as per the schedule shared by the technical team. So in the meanwhile, this is a lunch break. We will meet after 1:30 p.m. Thank you everyone. We will join again at 1:30 p.m.